It is April 29th of 2026, and this is the Court Gallery. Today we start with Judge Middleton and a young woman's heartbreaking story of being manipulated into crime by an abusive boyfriend. Then, the mood shifts when Judge McNally absolutely unleashes on a lawyer for trying to sneak an order past him. The tension keeps building as Judge DiSanto is left speechless when a domestic violence suspect yells an expletive after hearing his bond. And it all culminates in Judge Stewart's courtroom where a combative father completely melts down, sabotaging his own custody case. This is raw and unfiltered, and you have to see it to believe it, ladies and gentlemen. And as always, it all starts right now.
We had about 4 or 5 arraignments set for yesterday morning, and we had morning chaos because we didn't have any power. And one of our defendants from yesterday is here today, which I appreciate. Her name is Mackenzie May Davey. Would you come forward, please? Good morning.
Morning.
When you got here yesterday morning, what did you find? Power lines down in the street? And
Yeah, actually, my dad is a journeyman, so he's down here in Three Rivers from where I used to live. I actually just got back in contact with my parents because they didn't want to talk to me because of who I was with and why I was down here. My dad actually is the one that dropped me off today. But when I got here this morning, yesterday morning, I seen the telephone pole down the road, and I talked to this gentleman right here, and he told me to wait until 10. And then I got a little bit closer to 10, and I was like, you know what, I'll just ask him one more time. And he suggested that I come back.
well, he was the only one here. He was standing here in the dark with no electricity, trying to tell people. And those are the instructions we got. We're going to try to open by 10. We're going to try to open by noon. And the power wasn't turned on until sometime late last night.
I don't want to say I'm grateful.
What?
Because I don't want to say I'm grateful for the power being out because I'm not from this area. I moved down here to be with a man who turned out to be very abusive. I actually went to Cassopolis courthouse yesterday because my ticket got all water on it because I've been homeless, so it was kind of like smeared. And when I got to Cassopolis courthouse, they're like, "Oh, it's okay. We'll call for you and see if anything happens." And the lady came back like 10 minutes later, and she's like, "Nobody's answering."
Yes, it was a rough day. So let's take a look at yesterday's tickets and find yours. All right, you got a ticket at Walmart on April 5th for retail fraud. They charge it as a misdemeanor under Three Rivers ordinance. That's a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $500. Mr. Timothy Reed, the Three Rivers city attorney, is also the Sturgis city attorney, is here. Mr. Reed, I don't know much about it from the ticket.
I don't have
$135.42 in merchandise, barcodes removed, so items could not be put back on sales floor and sold. That's what it says on the ticket. Let me ask you a couple of questions. Where are you from originally?
I'm from a town called Morley, which is up towards Big Rapids, like where Ferris State University.
Yes.
That's where I'm originally from.
There's a companion town to Morley.
Yes, there's Altona. There is Stanwood.
Yeah, Morley Stanwood.
Yep.
I think they share a high school.
Yep. I graduated from Lakeview High School, which is right next door.
Okay, are you on probation or parole anywhere else?
No, I've never been in trouble before.
All right. So you know what I know. I don't know if this is the sort of thing you would take a civil infraction on with restitution or just leave it as it is.
I don't have the files, I don't have a report with me, like I said, today, so it's line as well. I prefer just, we can set a pre-trial and come back. And the file and get more information from the most appropriate resolution date.
All right, well, here's our options. If you plead guilty to this charge, I'm gonna give you a fine and I'm gonna order the restitution. I'm gonna give you some time to pay it. But it's a misdemeanor and it will go on your record as a misdemeanor retail fraud. The city of Three Rivers also has an ordinance. The state of Michigan doesn't, but Three Rivers, Sturgis, and some other communities do, where they can turn a retail fraud into a civil infraction. A civil infraction is not a crime. It's like running a stop sign or speeding. It's punishable by a fine. The fine will be $100 plus the restitution because they were unable to sell this stuff. But in order to do that, and there isn't even a guarantee that they will do that, but you'd have to come back down here from wherever you're currently living to have a pretrial with the city attorney once they get more information about it. So if you plead guilty, I'm going to give you a fine and I'll give you time to pay it. If you plead not guilty, I'm going to set a pretrial and ask you to come back in a couple of weeks to discuss this further. What would you like to do?
I just like to plead guilty. I want to go home.
All right, anybody threaten you to get you to plead to this
No,
or promise you anything?
no.
They say I make all the girls cry. I don't really try to, but sometimes the stuff is,
It's not this. It's the situation that led me up to getting here.
all right. They didn't give you an advice of rights. So let me go through those with you. Do you understand that if you do plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury? There will not be a trial. Do you understand that?
Yes, Your Honor.
If you had a trial, you'd have the right to be represented by an, there's some Kleenexes right there. You'd have the right to be represented by an attorney. If you could not afford an attorney, the county could appoint one for you at county expense. Or you could hire one. You could afford it. You had a trial, you'd have the right to take the witness stand and testify on your own behalf. You don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes, Your Honor.
All right. Were you in the Walmart store on April 5th?
Yes, Your Honor.
And did you change the barcodes on some stuff?
I was advised to take them off. Yeah.
All right, by this ne'er-do-well boyfriend we're talking about?
Yeah. Ex-boyfriend.
All right. What kind of stuff was it?
Game cards.
All right, that's the kind of stuff people sell for money rather than, and they're popular theft items from Walmart. So what was he gonna, you were stealing them for him and then he was gonna sell them?
He was gonna trade them for food because neither one of us had food. He had broken up with me before I did that, and I was sleeping on the around here in Three Rivers, and then I found a lady that let me stay with her tent, and she kicked me out after I got in trouble. So he told me I could come back.
Well, where are you staying now?
I've been staying with my ex's baby's mother.
All right, well, you said you reconnected with your parents.
Yeah.
Are you able to go back to Morley?
Yeah.
What kind of work have you done?
My most recent job, I worked at Menards, but I had basically was told to quit working there because I wasn't trusted by my significant other. But before that, I was working with my dad as a technically a mechanic. I did like oil changes and stuff on the bucket trucks for the linemen and the journeymen.
We don't really have to do this, but when Judge Welty was here, we created different judgments for different kinds of offenses. So we have one for Three Rivers ordinance, retail fraud. Where's this ex-boyfriend?
He lives in Marcellus, or he used to. I have no idea where he's at.
It sounds like X is the best way he could be.
Yeah, he put his hands on me, and I just had a miscarriage because of it. And hey, the reason I don't know where he's at is because he's off with his new girlfriend.
All right, well, this is a $75, that's her problem. This is a $75 fine, $125 in court costs, and $136 of restitution to Walmart. They're also barred from Walmart, all of them, for 1 year. Did he get charged too, or just you?
Just me.
Yeah, this was a bad deal all the way around. The amount owed is $336.
He sent me in, and then he went in after me. And when he seen that I got in trouble, he hurried up and ran out the store. And then he left me there, drove away.
Well, he sounds like a real winner, so I said maybe the best thing for him to do is be your ex-boyfriend. A lot of the young women I see, a high percentage of them suffer from the same thing. It's called bad men.
Bad memories in a bad generation.
All right, I want you to go out to the counter. I want you to set up a payment plan with the ladies out there to pay this fine. You can't go to Walmart, any Walmart, for the next year, and this will show as a misdemeanor on your record. All right, you go with the court officer. All right, this is file number 26268OT, People versus Pablo Pena. And it was charged originally with driving with a valid operator's license. The matter was reduced by the Three Rivers City Attorney to allowing another to violate the motor vehicle code. Driving occurred allegedly on February the 17th. The defendant pled to the allowing another to violate the motor vehicle code, which doesn't go on his driving record. That plea was entered on March 17th. I set for sentencing out for April 21st at 9 a.m. to see whether the defendant had paid on any of his other fines and costs. He did not, at least as of April 21st, and he didn't show up on April 21st. So I issued a bench warrant for his failing to appear with a 24-hour notice. The defendant's girlfriend called 2 days later. No, the same day, April 21st. And I hate that. You're a big boy. Your mom or your girlfriend shouldn't have to call on your behalf to find out why you didn't show up for court. But instead of you showing up or calling, your girlfriend called to figure out what the deal was. And then you actually came to the courthouse 2 days later, and they reset the matter for sentencing today and did not issue the bench warrant. So you had a number of other unpaid fines and costs.
I did make another payment.
I saw that you made a payment on April 23rd.
Yep.
And excuse me. But as of the 21st, you had not. So I suspect what you didn't do is you didn't show up because I was going to put you in jail because you hadn't made any payments. Then 2 days later, you did make some payments on these. I believe you currently do have a valid driver's license.
Yes, I do.
Which is part of why they gave you this allowing another charge.
Correct.
But it's a pain in the neck when you don't show up when you have to. Your girlfriend calls, you show up, we recall the bench warrant, we reset the thing. In the meantime, you come in after the fact and did make some payment. So that's a plus. I asked him to run a new driving record. Have you got any other tickets since this?
No, nope.
Yeah. Is your circuit course still pending?
Yeah, yeah.
What's the status of that?
I go for sentencing next month.
You were working someplace. Are you still working?
Well, I was just starting. I was actually just gonna start a job at Precision Wire, and
Yes.
I ended up having to go to the hospital. I had an asthma attack and almost went into cardiac arrest again. So no, not currently. I kind of delayed everything.
Well, you told me you thought they had a job waiting for you back at,
Yeah, yeah.
but it didn't work out.
No, that's the next day when I was supposed to go in. I was in the hospital.
All right. She did give me a new driving record as of today. You're still valid. I don't know what they're gonna do to you as part of your sentence in the circuit court. It won't be Judge Stutzman doing the sentencing. I don't know if it's gonna be Judge Kane or one of the visiting judges that we've had. How much did you pay on the 23rd?
It's like you're on. Yeah, 38. 38 or something.
As I said, I was reluctant to just keep doing these fines when you don't pay the fine. But, and I was not very happy when you didn't show up. Why didn't you show up on the 21st?
I didn't show up because I had a court date the next day also, so I got them mixed up.
You didn't show up for that date either. I didn't see you till the 23rd. So did you show up
It
on?
was circuit. I had circuit court the next day. I had circuit court the 22nd, so I just got them mixed up. That was all.
Did you go to circuit court on
Yeah.
the 22nd? Is that when you entered your plea?
Yep. No, it was the 22nd. It was the next day. Because then the day after we had to come here to.
No, it's just court. We call the courthouse.
Called on the 21st. You didn't show up here until the 23rd.
Yeah.
Yeah. Yeah, it was the 22nd.
All right. I don't know what to do with this. Gotta give you about 5,000 days in jail, but for this, exactly the crime of the century. You kept driving. You have a number of other stuff which does not involve driving. I'm looking at your driving record. Your last driving was Kalamazoo 21, no proof of insurance. And then your driving suspended was here in 2020. But sometime between 21 and now, you got your license back. You had improper plate. Oh, that was here in 24. In
But I make
Kalamazoo.
another payment today too.
7/27/24. And you got another one. Controlled substance offense. All right. I'm just gonna eat this, I suppose. You did have counsel in some of these other cases, but you did not in this one. This carries a maximum $100 fine. Are you in a position to make any payment today?
I was planning on making a payment, yeah.
Or how much you pay today?
Maybe $25, just
All
my,
right,
my
that's better
payment.
than a poke in the eye. $100 fine, $75 crime victims' rights fee, and a $50 state minimum fee. If I were to put you in jail, it'd be a giant headache for all concerned. The jail doesn't have any power right now. They're running on a generator. Things are all screwy with our arraignments. And this isn't the kind of a jail offense anyway. But I'm gonna give you a $225 fine as part of the payment plan. You to make payment today. I don't know what is gonna happen with your circuit court case. You could potentially end up in the probation center. I don't know what the recommendation will be.
Yeah.
Who's your lawyer in that case?
Casey Strong, I believe it is.
All right. Next time you miss court, call yourself. You're a big boy. Don't want to sign it to your girlfriend or your mother or somebody else. You take care of your own business. Anyway, I want you to go out to the counter. This will go on your record, but it won't go on your driving record because it's allowing another. So it doesn't go on your record. But you go out, pay that $25 today and continue your payment plan.
Okay,
All right, you're good to go.
thank you.
All right, good luck in circuit court.
What was that?
Good luck in your circuit court case. All right, that wasn't much, but we took care of it. Our trial starts at 1. I'll stop the live feed and have you sit here and watch me type.
Eric Tarenti Boy Bagaya, Jr., 26F262289. Your appearance?
Oh, Judge Patrick Reynolds, P76.
Oh, this is the one.
Tomorrow.
Yeah, I know. This is the one. I want you up here. Your appearance.
Patrick Reynolds, P76343. Sorry, Judge, I was very confused.
Well, I called it because I got the stipulated order adjourning bench trial.
Correct.
I had told you last time I was not going to adjourn the trial.
I understand.
Why in the world would you do that and submit that with the hopes it's going to get by a judge? Either that or you thought I was kidding.
No, Judge.
I don't kid in here. I have a very good sense of humor outside of here, but I told you I wasn't going to adjourn this. And then I get a stipulated order, like I sign 150 to 200 orders a week probably in judgments. Why would you submit an order, a stipulated order adjourning a bench trial when I just got done telling you I wasn't going to adjourn it? I hope you don't do that in other courts.
Judge.
So listen to what I'm telling you, counsel. I am not happy about this. I don't fool around in here. I'm not kidding. You guys had multiple pretrials. And now all of a sudden there's this urgency to adjourn because your client is going to start a job. If you had a pretrial on February the 5th, 19th, 16th of April, February 5th and 19th and March 19th and April 16th. And now you're telling my clerk your client's not showing up and you want to know when you can walk them in? Listen to me very carefully. If he dares plays games with me like that, he better have a lot of money. And don't think if you walk in here on Monday or Tuesday or Friday that I'm going to just say, oh, let's let bygones be bygones. He will be sitting in that lockup unless he's married to a physician for the longest time. But more important, I'm disappointed in you. When I tell you I'm not going to adjourn something, you don't submit a stipend order to adjourn behind my back with the hopes I'll forget about it and sign it. I'm serious as a heart attack. Why would you do such a thing?
Mr. Volya? asked me if I could do whatever I could to get it.
You brought it up. I said no. Why would you do such a thing? I don't care what your client asks you to do.
Judge, he finally got it before. He has 2 weeks where he can't.
This is an animal violation case. It's a dog bite.
It's a domestic violence, Judge. And they're going through a custody issue, so that's why we were trying to get it so the custody issue would not affect his.
You mean to tell me if he starts one day later, he can't get a job at Ford Motor Company?
Judge, the email said that he has to be there for 2 weeks straight. Otherwise, he will be terminated from the job. There's no exceptions, no excuses.
When is he supposed to start?
He started on Monday, Judge, so I think he's gonna miss work tomorrow. And have to reapply to. For.
Listen. I thought it was an animal violation, but it doesn't matter.
Now, did you?
Well, why so many? This is a domestic violence case. That's fine. But why so many pre-trials? If you guys needed to push this through, I'd have given you a trial date 6 weeks ago.
Judge, we didn't want to push this through. We wanted to work with the family law to get their custody issue set up at the same time as this was being resolved. And they were supposed to have a custody hearing last week, and it's been a contentious issue. So, and he wants to be able to support his 2 children with the victim. He was a former police officer.
I don't care who he was.
And he lost his job, and now he's been working as a plumber, but he's like, I finally have a job to get in at Ford. I can't leave my kids and move some other place.
I know, but if he told you that,
Judge, I begged him to set it. I said, can you start 2 weeks later?
listen to me. If he told you that, I vaguely remember you saying something about starting a job. Maybe you brought this up.
I don't believe I did, Judge, because I didn't know. He said he was looking for a job. He was waiting on Ford to get back to it, but I don't know if I brought that up. I did bring up studying in custody. I wasn't trying to sneak anything by the judge. I just.
No, but you can't do this. I was really surprised. I didn't think you would do something like this. I mean,
Well,
you could have filed an emergency motion then and it been explanatory. It said this, that, and the other. All I've heard is adjourn on this case. I don't want to cost anybody a job. Heather, I'm going to forget that Mr. Nienhouse handled this inappropriately.
Judge, I take full responsibility.
Hang on. I'm going to adjourn this. You called Mr. Cayley's office. They already submitted a stip in order. I'm going to adjourn this 2 more weeks. Is that going to do it? May 14th?
Yes, Judge.
You sure?
Yes, Judge.
Because you said he started this last week and he needs to be there for 2 weeks, right?
He told me it was 2 weeks. He can't. I was like,
All right. Okay, fair enough. For some reason, I thought this was an animal violation.
no, Judge, this was
We're going to adjourn this to, or is it May the 13th, Heather? No, May the
No,
14th.
it'll be May 14th, Judge. Do you want to
And
do
I'm
it
here
at
that day,
11
right?
o'clock? Yes, you are.
What time are we going to do this?
Do you want to do
Judge,
11? Are we doing it as a trial that day?
Yes.
So you want
What?
to do 11 o'clock?
What?
I was gonna say I have a Dearborn at 8:30 in the morning, so if I could just have it after 9:30 or 10.
I'll make it 11. May 14th at 11. I'm going to forget this happened, by the way. Next time, file a emergency motion. I'll accommodate you with an emergency motion, but I felt like you were trying to get one by on me, and I don't like that.
No, Judge, as soon as I got information from Mr. Bogia, I reached out to Mr. The EPA,
May 14th. That's what we'll do.
and I was like, I told him what's going on. I was
There's
like,
no sense groveling any further, but I was disappointed in you. That's all I'm going to tell you. It's forgotten. People against Christopher Brian Bradley, Jr., 267841844 A and B. Make sure you call Mr. Cayley so he can call off his witnesses on that case tomorrow. Will you please, Heather?
Okay.
No, man. You can call him too. That's fine. All right. Your appearance,
Patrick Manhattan, P76343, Judge.
sir, your name.
Christopher Bradley.
All right. So we have a disturb the peace in an A and B And does he stand mute and waive formal reading?
Yes, Judge.
And so now he's going to plead guilty to both of these, both the A and B and the disorderly under section 771.1. I got to call in the prosecutor real quick. Mr. Urick, please. I can't do a 771 for 18 months.
Okay.
It has to be disposed of within 12 months. FIDA you can, 769 you can, 7411 you can, any of these other statutes, but you can't do it on a 771. So he's just going to have to change it or do something else, but I can't do 18 months probation on it.
I should have thought that myself.
That's all right.
I know sometimes you can waive that.
That's all right. Well, I don't.
Yeah, no,
Okay, so, sir, do you understand? So first of all, he stands mute, waives formal
Yes,
reading,
sir.
right?
Yes.
And now he's going to plead guilty to these two charges, disturb the peace in A and B, and then there's going to be a plea of, Urick, your name?
Good morning, Your Honor. William York on behalf of the city of Winnebago.
I can't do 771.1 for more than 12 months.
Is that right, Judge?
Yeah,
I apologize.
there's nothing to apologize about. You want to just redo it to 12 months, or you want to do something else with Mr. Nyans?
Do it 12 months if the court please.
All right, good enough. So it's going to be 12 months, and that's still agreeable, obviously, with your client, right? Mr.
yes, Judge.
So if you plead guilty to that, sir, I want you to understand that each of these are punishable by up to 500 fines, 90 days jail, costs, or all those. I'll take them under section 771.1. The conviction will enter now. I'll send you for a pre-sentence report. And if you're compliant at the end of the year, the case will be dismissed. Do you understand that?
Yes, Your
And
Honor.
did you sign, read, and understand the advice of rights?
Yes,
If you plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that? Okay. Do you have any questions on any of your rights?
No, Your Honor.
To the charge, disturb the peace, how do you plead?
Plead guilty.
To the charge assault and battery, how do you plead?
Plead guilty, Your Honor.
On March 15 of 26 at 1:44 PM, were you at 22900 Allen Road near Weston Woodhaven?
Was I near? Yes, Your
Yeah.
Honor.
And what, is that a business establishment?
Yes, it is, Judge.
What is it? What business is that?
It's outside of Christoph's, Your Honor.
Okay. And what happened that makes you guilty of those two offenses? Disturb the peace and assault and battery?
Mutual combat, Your Honor.
No,
Well,
so let me,
No, I mean,
can I,
no, let me ask the questions. Did you come into contact with Joseph Clinton?
yes, Your Honor.
Did you know Joseph Clinton prior to that? Did you just meet him that day?
That was our first meeting, Your Honor.
Okay. And what happened? Did you strike him in any way?
I did strike him, yes, Your
With what?
Honor. My hand.
This? Okay, where'd you strike him at?
Space, Your Honor.
How many times?
Unknown amount, Your Honor.
Pardon?
Unknown amount, Your Honor.
So you punched him in the face multiple times, is that fair?
Yes, Your Honor.
And were you disturbing the peace in some other way? Were you yelling, screaming, swearing?
Other people got out of their cars and it caused the disturbance. Yes, Your Honor.
Okay, so what happened? Why did you punch him?
He almost T-boned me and my children, Your Honor.
All right, so he was backing out of a car, out of a parking lot,
No,
or?
it was at the intersection, Your Honor.
Okay, so you got angry with the way he was driving. Is that fair?
Yes, Your Honor.
And then you accosted him or came up to him and started yelling at him. Is that fair?
Yes, Your Honor.
And then what happened? Did he ever punch you or swing at you or take a strike at you before you punched him?
Before, no, Your Honor.
Not before.
Before, no, Your Honor.
So you were the aggressor first. Is that fair to say?
Yes, Your
And
Honor.
that you weren't acting in self-defense?
No, Your Honor.
Are you on probation or parole right now?
No, Your Honor.
Anybody force you to plead guilty?
No, Your Honor.
You're satisfied, right?
yes, Judge, thank you very much, I appreciate that.
I'll accept the plea. I'll take it under, under 771, both of them. And I'll make them 12 months. And we'll set it under, I'll take it under 771.1 commencing on the date of the sentence. I am going to order, he wasn't under the influence of anything, was he? You agree this wasn't the right way to handle this, right? Okay, fair enough.
Told you, I'm gonna take responsibility.
I got it. Mr. Nienhuis, I'm gonna give him 3 sentence report. If you want, maybe I can even do it the same day as your other case. We set it for May 14th, right, Heather?
Yes, at 11 a.m.
Yes, Judge.
Well, let's set this one for 10:45. How's that?
Perfect, Judge.
And then I'll sentence him then. And getting back to the other Mr. Nanos, maybe it was just a misunderstanding. I'm gonna give you the benefit of the doubt. And I was just upset when I got a stip in order to adjourn when I'd said I hadn't. And next time I just encourage you to file a motion and explain it, and I'll be reasonable with you, okay?
Okay, please, Judge, I appreciate you.
All right, so you're gonna go down, no problem. You're gonna go down the hall. And just to not carry on here, I've always liked you, so you're gonna go down the hall, get your notice, and then you're going over to probation where you'll be interviewed, okay?
Judge, I do have a question. Can we do
Sure.
it that day, or are we gonna notify the victim on this, or no?
You have to notify the victim.
So
The
does it have to
probation-
be on a Woodhaven day or no? If we have to notify the victim?
Yeah, it should be. That's Woodhaven though, right?
Not on that other day as his other case, because that's a Thursday.
Because that's a flat rock case, Judge.
Oh, jeez.
Judge,
Yeah,
I'll make
so
a
we would-
Okay, yeah.
We'd
we're
have to
gonna
do it on
make
the 13th.
My mistake.
No problem, Judge, 19.
Yeah,
And Judge, are both of these being taken under 7711?
both of them will. Yes.
Okay, thank you.
So we'll make it May the 13th then. Are you good at 8:30 or?
Can we get a little later, just because I don't.
I don't have a problem. I'll make it 10:30. How's that?
That works, Judge, thank you.
Okay.
Be here a little early.
I gotta set bond conditions though. I neglected to do that. Your client doesn't have any warrants out, does he?
No, Judge.
He was never fingerprinted on this though, was he?
No, he was not, Judge.
So, sir, listen, I have to order you to go prints, okay? So here are your bond conditions. I'm gonna give you $1,000 personal bond, okay? $1,000 personal bond on these. And we'll give you a copy of the bond sheet. You cannot leave the state without the consent of the court or violate any law or ordinance. You must appear in court as directed, okay? And I'm going to go ahead and order that you go over to the Woodhaven Police Department to be fingerprinted and photographed by 1 p.m. today, that you not purchase, possess, or possess firearms or other dangerous weapons, that you not enter the property address at 22900 Allen Road. That's the Christophs. And also that you not have any contact with the victim, Joseph Clinton, okay? So you cannot have any contact with him. You cannot have anybody write him, phone him, see him, text him, email him. You cannot do any of those things for you or on your behalf. You have anybody else do any of those things for you or on your behalf. Do you understand that?
Yes, sir.
And I'm gonna fill out an order for prints, which they're gonna send over there, so you have to go over to Woodhaven today, and we will go from there. Anything else, counsel?
No, Judge, we're gonna leave it appearance, and we'll split for probation, and then we should be done by once, we can get to it.
Absolutely. Thanks a lot. Have a good day.
Thank you, Judge.
Thank you.
We are on the record in BU 2025 TR 168, State of Kansas versus Maestro Rodriguez Saunders Jr. Jared Regier for the state. Defendant Saunders appears in person and pro se. We had a first appearance April 30th of the year 2025. Defendant failed to appear, and it's taken us a year to get you back here, Mr. Saunders. What's taking so long to get you back here?
With that, what happened was I had my court date, but when I got pulled over, you have to like text and call the number or whatever, and then you get your court, get Zoom information. And I did that, but they never sent it over. So the day before my court date, I called and I said, hey, because I went to court like once or twice before, so I understand how it works. So I was like, I know I had court the next day, but I still didn't get the information. So I called and I said, hey, my court day is tomorrow, and I still didn't get the information. what is that about? And she said, sometimes the system just does that. And she said, you should have it by tonight or by the morning time before your court date. So I said, okay. And right now I'm in school. So I had a morning class that day. So I went to class and I said, when I get out of class, I will call and see because I still didn't get it in the morning time. So after class, I called back and I was like, hey, I talked yesterday to a lady. Would you by any chance to be able to look up and see when my court date is? Because I mean, what time it is? Because I know it's today, but I never got the time because y'all never sent it to my email. And then she searched up my name and she was like, you had court this morning at 9 o'clock, so you already missed it. So I was like, what do I do now? Because it looks like I just missed court, but I did what I needed to do, but y'all didn't do what y'all needed to do. So I didn't get a name or anything. So I didn't thought it's gonna be that big of a deal, but like she had like the worst attitude, and then she sent me to this number to like Topeka. She gave me a number to call in Topeka, and I called that number for probably like 2 weeks straight, and like it's always busy. It never answers. No one answers. And honestly, after some time, I just kind of forgot about it. Honestly,
All right, so it wasn't your fault that you failed to appear. It was my clerk's fault. It was my fault, and it was the Department of Revenue Licensing Division in Topeka that you missed court. Did I just understand you correctly?
with the Zoom information, yes, ma'am. So I never received the Zoom information, but I called like I was supposed to.
You know, you can always come to the courthouse. You don't have to appear by Zoom.
Yeah, but I don't understand how that works. I'm not from here. I just go to school here. I don't
Well,
understand how to.
here's the thing, sir. If you're gonna come to Kansas and you're gonna disregard their laws and violate their laws because you didn't take the time to learn our driving laws, which are compacted with the other states, by the way, then you better make sure you figure out the consequences if you're not gonna follow our laws.
Yes, ma'am.
When you were told, when you were here, no, you failed to appear. You've never been here before.
No, ma'am.
I am not accepting that you did your part and that the clerk failed their part and the court failed its part, the Department of Revenue failed their part. Why don't you just throw in Jared Regier, the county attorney, and blame him too? If you're just blaming everybody but yourself. All right, I'm going to give you another chance at this, even though it took you a year to
Yes,
get
ma'am.
in here. Why did you decide to show up today since you haven't for the last 4 or for the last
Uh,
year? Did you
pardon?
get arrested? I said,
Oh
why
yeah,
did you?
yes, ma'am. Yes, ma'am. Yes, ma'am. I did. Yes, ma'am.
All right, so you didn't appear voluntarily. You only appeared because you got picked up on the bench warrant of 2,500 that was issued for your failure to appear the day you failed to appear. Okay, well, let's start over. You're the
Yes,
one
ma'am.
that's in this court.
Yes, ma'am.
I didn't go out looking for you. None of these people you're blaming went out looking for you. I don't know what brings you here other than the allegations. And we'll
Yes,
find
ma'am.
out if it's true that you violated the law or not.
Yes, ma'am.
But at this time, you better show up when you're told to show up and do what you're told to do, or you could end up getting locked up in jail. All right,
Yes, ma'am.
you are in Kansas right now, though, right?
Yes, ma'am.
Your warrant told you and your bond told you to person, right?
Yes, ma'am.
That way we don't have to worry about the clerk not getting you your Zoom code. By the
Yes,
way,
ma'am.
I do have a note from the clerk that said she could not send you Zoom codes because she did not have a valid email for you. So that's why the clerk didn't send you those. Although if you didn't get them, I usually say call a few days before if you don't get your Zoom codes.
Yes, ma'am.
All right. So, Mr. Saunders, let's look at your charges since it's been a while since you and I have.
And Your Honor,
Mr. Regier.
forgive my interjection, but is the court also on the record in 25 TR 1034?
I was not, but I see that we should be. You also are here on BU 2025 TR 103.
Christopher.
Is-
I-
Before.
August 1st to 25. But for some reason, the county attorney gave you a break and took it off the docket rather than giving you another warrant. That's why you didn't blame Mr. Regier. His office gave you a pass on one of these. Okay, so let's be clear. Like I said, we'll start over here. BU 2025 TR 168 says in count 1, you operated a motor vehicle without a valid license in Butler County on August 19th of 2024. This is a Class B misdemeanor. If convicted, your fine could be up to $1,000. Your sentence could be up to 6 months. On count 2, you're accused of not having any liability insurance or not being able to provide proof of it on that day as well, August 19th to 24, another B misdemeanor. This charge, though, has a minimum fine of $300 up to $1,000 and a possible 6-month sentence. Now then, let's look back at that other case. 8. That one charges the same type of charges. Operating motor vehicle without a license, no insurance, August 19th of the year 2024. But then the 2025 TR 1034 charges you with driving while suspended January 29th of the year 2025. A B misdemeanor. If you have no prior convictions for driving while suspended, it's a B misdemeanor. As I said, up to $1,000 fine and 6 months in jail. If you have a prior conviction for driving while suspended, those misdemeanors go up to A's, which means up to a year in the county jail and a $2,500 fine. But so far, they're each charged as B misdemeanors, and I know why that is. So you do have the right to an attorney in one or both of these cases. You can either hire an attorney if you cannot afford to hire an attorney. You can apply for a court appointed and see if you qualify for court appointed. You can waive your right to an attorney and represent yourself. Whether you represent yourself or hire an attorney, the county attorney does have the diversion programs. You may or may not qualify. You'd have to go online, as I've been saying all morning, and see if you qualify and apply if you do, and then do what the contract that you do, and they would dismiss the charges. At this time, do you intend to hire an attorney, apply for court appointed, or waive attorney and represent yourself, sir?
Represent myself.
You understand you can hire an attorney, and if you cannot afford to hire an attorney, you can apply and if you qualify, you can have a court appointed.
Yes, ma'am.
But you don't want an attorney in either one of these cases? Again, you're looking at potential jail time up to 6 months on each count.
Oh, well, okay, you can hire me on.
I'm sorry, I'm not understanding you.
I say it's fine. I'll hire an attorney so I could get more understanding on.
Okay, you can't afford to hire?
No, ma'am, I can't afford it. No, ma'am.
You cannot. So do you want to apply for court appointed?
Yes, ma'am.
All right. You told me something about it at one point, at least you're a student. Are you still a student?
Yes, ma'am.
Where do you go to school?
Butler Community College.
All right. So you're a college student. What year are you in?
I'm in my junior year. I mean, no, my sophomore year.
Say that again, please.
My sophomore year.
You're in your sophomore year? Okay.
Yes, ma'am.
Do you have any income, a paying job?
No, ma'am.
Okay. Are you here on scholarships then and grants?
Not scholarship, but I'm here on a student visa.
Okay. Who's paying for your education?
My parents back home.
Okay. And where's back home?
The Bahamas.
Bahamas. It's a
Yes,
little bit
ma'am.
different. That's a little bit different than Kansas.
Yes, ma'am.
Weather-wise, at least. All right. So without any income other than your parents paying for your education, you would qualify for court-appointed attorney, and I'll appoint attorney Darren Patterson. He has a contract willing to take these types of cases, and he's been doing it for quite some time, very experienced. You'll need to walk across the street to his office and give him your contact information and your next court date on both these cases. He's appointed on both, Jenna, and remind me, we're putting these on Patterson's docket. What was that date again?
July 20th.
You'll need to be back here July 20th at 8 a.m. on both cases with your attorney, Mr. Patterson. Now, Mr. Patterson will have your Zoom codes. So no more of this excuse about what the clerk didn't give them to me or this or that. From now on, this is your responsibility. Your responsibility to walk across the street and talk to your attorney and to be available to your attorney so he can help you with these charges. Your responsibility to make sure you get the Zoom codes and you get to court July 20th at 8 a.m. I've got you down by Zoom, but I'm thinking maybe you ought to just come in person so we don't have the Zoom code problem again. I'm going to make that the order, that you appear in person. I've seen people walk from the college dorms to get here. It's not a walk I'd be looking forward to, but it's not the end of the world either. I could do it if I had to, believe it or not. All right, so I'm going to continue the bonds you've already made with the conditions that you go across the street today to Mr. Patterson, give him what information he needs, and that you reappear July 20th at 8 a.m. Mr. Aguirre, is there anything further I need to take up?
Yes, Your Honor, if the court is prepared to hear an oral motion by the state.
Go ahead, please.
Your Honor, if the court is continuing the bonds in both of these cases, the state is tending by the Your Honor, if the court is continuing the bonds in both of these cases by the state.
Street today to Mr. Patterson, give him what information he needs, and that you reappear July 20th at 8 a.m. Mr. Aguirre, is there anything further I need to take up?
Yes, Your Honor, if the court is prepared to hear an oral motion by the state.
Go ahead, please.
Your Honor, if the court is continuing the bonds in both of these cases, the state is tending oral motion to add an additional condition of bond that this defendant be subject to pretrial court services monitoring. The state does not make this recommendation lightly. However, pursuant to the informations in both these cases, these are cases where that appear to involve significant offenses with alleged occurrence dates at close proximity, August 19, 2024 and January 29th of 2025. Additionally, it is the state's information is that this is defendant with two other cases in other jurisdictions that are currently pending, one in Lincoln County, 25 TR 37, with an alleged occurrence date in February of 2025, with at least one prior failure to appear in March of 2025. Additionally, a Sedgwick County case, 26 TR 2701, involving three alleged occurrences, including no proof of insurance and driving while suspended. While the state does recognize that these are mere allegations at this point, the alleged occurrence dates appear to be approximately 2 to 3 months prior to today's date. So the state does respectfully submit that is relevant insofar as setting appropriate bonds subject to such conditions as the court may deem appropriate.
You just told me that his record suggests he's been driving without license and insurance and other traffic matters since at least January 29, 25. That's what the record suggests. He's been
Your
doing that
Honor.
all across
Sure.
the state of Kansas.
Your Honor, the 2025 case, 25 TR 168, does appear to allege occurrence dates of August of 2024. In the first case, in the subsequent case, 25 TR 1034, both on the docket today, it alleged an occurrence date of January 29th, 2025. The Lincoln County case appears to allege a non-driver's license violation from February of 2025. The Sedgwick County case appears to allege multiple counts, including no proof of insurance and driving while suspended in February of 2026.
Well, I don't know if the Bahamas have driving laws, but we certainly do in Kansas and many other United States. And those driver's licenses require that you know how to safely drive. I don't know if you ever took a driver's education course or if you studied a driving manual or not. Talk to your attorney, Mr. Patterson, about that. Don't answer me today. But as a condition of your bond, don't you dare be behind the wheel of a moving car. Because unless you've taken a driver's education course and really studied the manual for driving, you may not even know what the street signs tell you to do or not do, and that puts the public at serious risk of jeopardy if you would hit them. And if you don't have insurance, you can't even compensate their medical bills. God forbid they don't die in the wrecks. Now, I don't know if these are true. These may be all just be allegations. You may have a license, or you may not even be driving. We'll find that out. But I feel like I had a little bit of duty to inform you that you are, as conditions of bond, not to be driving unless you've got a valid license and your automobile is working properly and legally in all respects. If you are found driving again, it could be a violation of your bond. And that's in any county in the state of Kansas or state in the United States. But you better get across the street and talk to Mr. Patterson before I find out any other allegations that I may have to act on today. Yes, sir. And think cautiously before you say anything.
Yes, ma'am. Those stuff that he was talking about, I mean,
All right, I'm going to stop you right there. Mr. Patterson will want to advise you before you say any more about that.
No,
I'm
I
not
just
holding that against you. I understand that you have not been convicted. But anything you say could end up being used against you in trial, and Mr. Patterson may not want you to jeopardize yourself or incriminate yourself like that. But if you insist on talking, I'm not going to stop you.
Okay. I don't say anything about that, but one thing that you said was that I walk from the dorms. I live in Wichita. I go to the Andover campus. So is there any,
bondsman? Okay. Do you have a bondsman?
Yeah, yes, ma'am.
Why don't you call your bondsman and tell him you need a ride? He may prefer to give you a ride than to lose the bond because you failed to appear.
Yes, ma'am.
Talk to Mr. Patterson about it. Yes, Mr. Regier.
The state's oral motion for pretrial court services monitoring as an additional condition of bond in both these matters.
I am going to order that. I'm like you, Mr. Regier. I don't take that lightly because court services is so busy with so many other tasks for the court. But I'm going to order pretrial court service supervised bond monitoring, meaning before you leave the courthouse, you need to walk down a couple feet down the hallway to court services and tell them you're there for bond monitoring. I know they don't like that, and I understand why they don't like it, and none of us like it. But you need somebody to keep reminding you about your bond and your obligations more than what you've been doing. So I'm going to order that you keep in touch with them, that they know where you are, and that you keep in touch with the court by coming to court. All right, so stop by for bond monitoring and then go over to Mr. Patterson's office. Keep your bondsman informed of where you are and that he make sure you get to court. Remind me, your bondsman is, I can look. A second chance bail bonds. I don't know who the bonding agents are in that, but like I said, I suspect they'd rather get you a ride to court than lose $1,000. And that's just on the one case. That doesn't include the bond on the other case. Make sure that court services know they're supervising bond in both your cases, 2025 TR 1034 and 2025 TR 168, and that your next court date is July 20th. I'm ordering that you be here at 8 a.m. in person, not by Zoom.
Okay. Thank you.
Okay, you're welcome. You're excused from today's hearing.
Okay.
Record in the matter of the city of Wyandotte versus Linnell Martin Jr. 251238 231467.
Good morning.
Good morning.
Good morning, Your Honor. Your Honor, John Oakley, 30758, on behalf of Ms. Martin, with respect to both matters.
Very good, thank you. And so, Mr. Martin, your name for the record, please.
Linnell Martin Jr.
Okay, so it appears as though in the 23 matter, it's a show cause.
That's correct, Your Honor.
Failing to pay. And then on the 25 matter, there's been a resolution with the pretrial, correct, counsel?
That is correct, Your Honor.
All right, would you like to place it on the record?
Your Honor, as to the 251238, I've had some lengthy discussions with the prosecuting attorney. I've viewed all of the video. I also provided Mr. Martin with the police reports. We reviewed the police reports. The prosecuting attorney has also spoken to the individuals at the hospital, and based on all of that, Your Honor, the people are offering that in return for a plea of responsible to disruptive behavior, the charges against Mr. Martin in this particular matter would be dismissed. I've explained to Mr. Martin his constitutional rights. I've explained to him what disruptive behavior is, that it is a civil infraction, and he wishes to avail himself of this plea opportunity. Is that correct, Mr. Martin?
Yes, sir.
All right, thank you. And thank you for dressing appropriately for court with your Oxford shirt there. Please raise your right hand. Do you solemnly swear or affirm the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
I'm sorry?
Yes, ma'am.
All right, and you heard the plea that was placed on the record, correct?
Yes, ma'am.
As to the amended charge of disruptive behavior, how do you plead?
Responsible.
You've gone over your advice of rights with your attorney, correct?
Correct.
And you understand all of those rights.
Yes.
And you understand the possible that by entering into a plea, you'll be waiving some of those rights, correct?
Yes.
And you also understand, sir, the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes.
And knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
And any immigration issues?
No.
All right. The court will accept your plea as knowing and voluntary, dismiss the original charge per the plea agreement, and that's $250, plus there's also a $50 warrant fee for a total of $300. I know you posted a bond. We can apply your bond, which leaves a balance of $50. So when can you pay that $50?
I'm supposed to start this job on Monday, but probably today.
How about I give you until June 1st on that, sir?
Sounds good.
Okay, and where are you beginning your job, sir?
It's at a factory through a temp service out here in Indiana.
Okay, and so then, sir, as to your show cause on 231467.
Your Honor, I believe I reviewed that. $400 some dollars.
I'm showing $600.
$600. Okay. He understands that. He understands that this is his financial responsibility. He would be needing a payment plan. to get this paid off.
Great. So I'm going to give you a payment plan of $50 per month.
Okay.
And I'll begin that June 19th. So that's another 2 weeks after your last $50 payment. And then it'll be $50 every month, sir, on the 19th of every month.
Sure.
All right. Good luck to you, sir. You can contact into the court so that you can, or you can even find the information on the website so that you can pay it online. Emily.
Your Honor, before Mr. Martin leaves, if your court could please put him into a breakout room so Mr. Serrano can speak with him.
I really just had a quick question.
Because he has some question. He has a matter with Mr. Serrano next week.
Oh, okay. Yes, we can do that.
Go back.
I have a question for you though, Miss. Trying to see if I could appear on Monday on Zoom.
That's what.
Because I can't make it out there, and I start a job.
Sir, you're going to speak with your attorney, Mr. Serrano, who's representing you on that matter. Okay?
All right, thanks.
You're welcome. We're going to put you in the breakout room and then we can address that.
Thank you, Honor.
Okay. All right. We are on the record in the matter of the City of Wyandotte versus Heather Fricky, 25851. Is that you, Mr. Westmoreland?
Yes.
Okay.
Attorney Corey Westmoreland appearing on behalf of Fricky. Ms. Fricky, would you please state your full name for the record?
Heather Patricia Fricky.
Okay, thank you. And so today is the date scheduled in this matter for the trial. And counsel?
Yes, Your Honor. And at this time, the city has please offered to dismiss the original obstructing the police search, and Ms. Fricky is prepared to plead guilty to one count of disorderly person.
Okay, and so ma'am, please raise your right hand. You solemnly swear or affirm the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes, sir.
All right, you heard the plea that was placed on the record, correct?
Correct.
As to the charge of disorderly conduct, count 1, how do you plead?
Guilty.
And you've gone over your advice of rights with your attorney, correct?
Correct.
And you understand all of those rights.
Correct.
You also understand, ma'am, the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency. Is that correct?
Correct. I'm sorry, I couldn't hear you.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, ma'am.
Any immigration issues?
No, ma'am.
Counsel, if you can please murder your client.
Sure. Ms. Fricky, were you in the city of Wyandotte on June 14th of 2025?
I'm here.
Were you in the city of Wyandotte on June 14th of 2025?
Was I in Wyandotte June 14th, 2025? Yes.
Correct. On that date and time, did you act in a manner that was disorderly?
I'm sorry, one more time.
Did you act in a manner that was disorderly?
I was very upset, yes.
And as a result, the police had to be called, correct?
Yes, absolutely.
Satisfied, Your Honor.
All right, I'm showing this is June 12th of 25. Did you say June 12th or June 14th?
June 14th of 20.
I'm showing June 12th.
Maybe the complaint was written on June 14th, so.
Okay.
Maybe June 12th.
Okay. Okay, the court will accept the plea as knowing, voluntary, and factually accurate. The court and counsel are in the court will dismiss count 2 per the plea agreement. Yeah.
Oh, you froze. Oh, you didn't freeze it.
No, I paused. Counsel, you asking for immediate sentencing?
Yes, Your Honor, I would like to know that Ms. Fricky has been in custody for roughly a week. I just be asking for credit for time served on her behalf. She took responsibility for her actions. she's just looking to get out and get back on track and stay out of trouble.
Well, it appears as though hanging with Mr. Nagel is going to be difficult for you to stay out of trouble, ma'am.
I'm staying away from Mr. Nagel at this point.
Okay, do the two of you still reside together?
We don't even have a home.
Okay, where are your 3 children?
They're his, not mine.
Okay, where are you residing?
I don't have a home.
Yeah.
I'm right now here. I'll figure it out though.
Well, yes, but you were arrested on the warrant, and when you were arrested on the warrant 1 week ago, you were still with Mr. Nagel.
Right, I'm not going back to. I'm going to go back home. I'm going to go back to Oakland County where I belong.
Who resides in Oakland County with you?
Friends, I have no family. My family is all deceased. But I do have good friends out there. I have no place in Wayne County. No one.
Well, ma'am, it would, were you consuming any alcohol in this state?
No. I don't drink.
You don't drink?
No, ma'am.
Since when, ma'am?
Since when?
Yes.
Since my last DUI 2013.
Okay. All right, so the court's going to, or in this matter, 10 days jail, credit for 7 days. The court's going to waive fines and costs, including the warrant fee.
Thank you, Judge.
Thank you.
Contact your friends in Oakland County so you can get back over there. Have a good day.
Thank you.
Okay, Mr. Martin.
Okay.
Yes.
Yes. Okay. So, sir, I need you to send in something from your employer that you're starting on Monday, and I will permit you to appear via Zoom on your matter Monday morning. Otherwise, you have to appear in person. So just send in something from your employer or your temp agency indicating that Monday is your start date for work.
Okay, and also I don't have the money to get out there. That's another thing.
Sir, hold on. Listen, I've been informed that you are requesting to appear via Zoom on Monday because you are starting your employment. Is that accurate or not accurate?
Yes, ma'am. And I would like to accept the plea deal that I was offered.
I'm sorry?
I said, and I would like to accept the plea deal I was offered.
You don't want to accept it or you want to accept it?
I would like to accept it.
I understand that, sir. So just send in something, some proof that your employment begins on Monday, and I will permit you to appear via Zoom.
Okay.
Okay? Just send it via email. You can send it to your attorney or to the court. Okay?
All right. Thank you.
All right. And then go ahead.
Not me.
Right.
Yeah,
You'll send it to Mr. Serrano, your attorney, Mr. Serrano, not Mr. Goldblatt.
Okay.
Okay?
Thank you, Ron.
All right. Thank you. Have a good day, sir.
You too.
Okay. So let's go on the record in the matter of the state of Michigan versus Michael Quick, 26184.
Ready, Governor. Here on behalf of Michael Quick. Mr. Quick, can you state your name, sir?
Michael Lee Quick.
Thank you.
Thank you. And today is the arraignment as your client is in custody and counsel the arraignment.
Yes, my client waives formal reading, stands to be for charges.
The court will waive the formal reading. Sir, you do have the right to have an attorney. If you're unable to afford an attorney, you may request one to be appointed to represent you. And you have, in fact, spoken to an attorney today, correct, sir?
Yes, that gentleman. Yes.
Okay. And you also have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. And you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yes.
The court's going to enter a plea of not guilty for purposes of the arraignment. Counsel, one question is, do you want to address time with your client? Because this court doesn't have a docket next Thursday as it's at a conference. And so instead of having the PCC in 2 weeks, it would be instead of it being in 1 week, it'd be in 2 weeks.
Yes, I can. Mr. Quick, the judge is trying to explain due to some docketing conflicts, you're entitled to have the next hearing scheduled within a week. The docket doesn't accommodate that, and she's asking whether or not you have an objection to pushing to 2 weeks.
No objections.
Thank you.
All right, the court will note that time waived. Probable cause will be scheduled for May 14th.
Take your hat off.
At 10 a.m. Also as to bond, and then I will give the detective an opportunity to respond as well.
Yes, Your Honor. I recognize the severity of the nature of the offenses in this particular case, but I would also point out these allegations are from things allegedly happened more than 10 years ago. Mr. Harrison has no criminal history. He's 63 years old. He owns his own home. He lives there with his wife and his one of his children. He's been gainfully employed. He's got training. His function is a DSP 1 and 2. That's a direct support professional. Been doing that for 4 years. He's got a career in the Navy. He did 4 years and then did reserve after that. He is, again, there's no indication of any criminal history in 63 years of life up to these heinous allegations, which he vehemently denies. We'd ask the court, I think, likely a GPS tether would be minimally invasive here. Beyond that, I would ask the court to consider personal bond.
Okay, Mr. Quick. How long have you resided in Harrison?
Resided in Harrison pretty close to 4 years. I'm currently in the second address in Harrison. I lived with my brother and his wife prior. In Harrison.
And sir, are you on probation or parole anywhere?
I'm sorry, I didn't understand you.
Are you on probation or parole anywhere?
No, ma'am, no, Your Honor.
Have you ever failed to appear in court for any reason?
Never, Your Honor.
Are you currently out on bond in any other jurisdiction, sir?
No, Your Honor.
So I'm a bit confused, sir. Do you reside in your own home or you reside in your brother's home?
And I think he was explaining that he'd been living in Harrison for a number of years. He first lived with relative in Harrison and then he bought his own home. Is that correct, Mr. Quick?
Yes, sir.
Okay. And what is it you do for work, sir?
I'm a direct support professional. I work with special needs.
Special needs children?
No, ma'am. Your Honor, it's adults.
All right. And detective, as to bond.
Your Honor, I would recommend the GPS tether. Absolutely no contact with the victim in the case, Miss Alyssa Hodgkinson. in any shape or form, third party, not to return to her address or her new address. And I know that the court issued $100,000 10% bond, Your Honor. I would be okay with that as well, Your Honor.
I have to tell you, it doesn't sit well with this court, given the nature of these charges and what your client does for work also, counsel. I have some significant concerns for the safety of individuals. Sir, is there something else you can do within your employment other than working with special needs individuals?
If I may, Your Honor, I don't believe. No, there is nothing there. No, nothing other that I could do. I don't believe.
If I may, unless I misunderstood him, I think he's been suspended from that position. Is that correct, Mr. Quick?
My feeling is that I don't work there any longer.
And why do you have that feeling, sir?
Just because of the nature of the work, when you're dealing with adults with special needs, they are considered. The word just went right out of my mind.
Vulnerable?
I'm sorry, the word just went right out of my mind. But they're. I just don't believe that MMI would want me to be employed there anymore.
Because you work with a vulnerable population?
Vulnerable, yes, ma'am. Yes, Judge, that's where they're considered vulnerable, at least in my view. And so, while in my circumstance, I just don't believe my employer would care to have me back.
Do you have any minor children, sir?
No,
Any minor grandchildren?
no.
The court, based upon the nature of these charges, given Mr. Well, how did you end up in custody, sir?
I was picked up at work.
Oh, okay. So the court's going to note, based upon Mr. Quick's residence, based upon the nature of these charges, the court does find for the protection of the community as well as the victim in this matter that the $100,000 10% bond that's been requested is appropriate. These are the following bond conditions. You're not to have any contact with the victim in this matter. That's phone contact, text message, email, social media, third party, anything of the like. You also are not to enter the premises at her home or place of employment. You're not to possess or consume any alcohol or drugs unless prescribed. You are not to possess or have access to any firearms or weapons. Do you have any of those, sir?
I have a couple of rifles. I'll have my brother hold on to those.
Is your brother legally able to have possession of those?
Yes, Your Honor.
You are not to be released without a GPS tether through Wayne County Jail, and you're not to have any contact with any individuals under the age of 18 or a member of vulnerable population. How long have you worked at that location, that employer, sir?
About 4 years. Well, 3. Let me see. It's kind of a blur because I spent time with the same company in Mount Pleasant, and then I transferred to the Clare. So I've actually been with Emma, my law, been with the clerk office.
Okay. All right. We'll see you back in 2 weeks. Have a good day.
Thank you.
Thank you, Your Honor.
Thank you. We're on the record in the matter of the Gregory City of Wyandotte versus Gregory Benson, 26553. I feel like Mr. Benson was just here.
Good afternoon, Your Honor. This is Neil DeBoy here on behalf of Gregory Benson.
Well, we've got Belcher.
George, could we do Belcher?
Straight up here.
On fire. Mr. Du Bois is so excited that I recognize these names.
Good morning.
We are on the record in the matter of James Belcher, 25571A and B, it looks like B. And then City of Wyandotte versus James Belcher, 26552.
Good afternoon, Your Honor. Neil DeBoy here on behalf of James Belcher Jr., who joined us from the Wyandotte Jail. Mr. Belcher, can you hear us?
Yes.
State your name, sir.
James Sean Belcher Jr.
Alrighty. So, counsel, today, since your client is in custody on a new charge of public intoxication, and then from the warrant because he failed to appear for his probation violation October 21st, both matter. So as to the arraignment on Mr. Belcher on the 26th case.
My client waives formal reading and stands mute to the charge.
All right, the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and then counsel as to the pre-trial.
So just for the record, we have on the older case, this is show cause. There's an allegation of 5 violations of probation requirements. And the newer matter is public intoxication of alleged occurrence of yesterday, 20 April. Is that correct, Judge?
Yes. So the okay. So yes, the new matter of public intox from April 28th. Then the probation violation, your client was actually scheduled for a probation jail review. He had failed to appear for his last review. And because on September 17th, for technical violations 1 through 3, your client was sentenced to 15 days jail. Then he had 5 additional violations. So that's where the recommendation on that matter is that he serve a suspended 15 days plus additional jail for new violations. And those new violations are failing to appear at FAN, failing to appear for an IOP, failing to appear for probation October 20th, October 6th, and October 20th for the failing to appear for probation appointment of 25, failing to appear for drug testing October 6th and October 14th. And he's absconded for 6 months. So, correct.
Yeah, Your Honor. Yes, I did go over this with Mr. Belcher and advised him of the allegations of the violations and the recommendations of the probation department. After going over that with him, carefully indicated to me that he does not dispute and acknowledges those violations.
Okay, so Mr. Belcher, it's my understanding that you're going to be pleading guilty to the new charge as well, correct?
Correct.
All right, sir, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes.
All right, and sir, as to the new charge, that seemed to be the easier one of them all, of public intoxication, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights?
Correct.
You also understand, sir, the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes.
And you also understand, sir, that you'll be waiving some of the rights that you've reviewed with your client or with your attorney, correct?
Correct.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
All right, counsel, if you can please refer to your client as to this matter.
As to the new matter, Judge?
The new matter, yes.
Yes. Mr. Belcher, do you recall being in the city of Wyandotte yesterday, last evening?
Yes.
And there's a police report that indicates that they spotted you in the vicinity of the Fast Splash car wash in Wyandotte, and that you had they identified you, and that you appeared to be intoxicated, stumbling across the street. Do you dispute those allegations?
No.
And you provided and cooperated with a portable breath test, and the result was 0.221. Do you dispute that?
Oh.
Right. I'm satisfied with that.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to that matter, and then we'll address sentencing in just a moment. In the meantime, you're still under oath on the probation violation matters. And sir, you heard the allegations as to the violations of probation, correct?
Correct.
As to those matters, sir, how do you plead?
Guilty.
And you've gone over your advice of rights for probation violation purposes with your attorney, correct?
Correct.
And you understand all of those rights?
Yeah.
Is that yes?
Yes.
Also understand you'll be waiving some of those rights by entering into your plea.
Yes.
And you understand the possible penalty as a result of your plea, whether in this court, any other court,
Yes.
or administrative agency. And knowing all that, you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
And any immigration issues?
No.
Counsel, if you can please refer to your client.
Yes, Mr. Belcher, you recall being placed on probation for an earlier matter in this court, correct?
Correct.
And I believe it was a guilty plea to a charge of loitering.
Correct.
Is that accurate? And yes. This court placed you on a probation. There were conditions of that probation, and now they allege that you violated in the following ways. That you were ordered to appear at the probation department on about 20th of October of last year. You didn't do that, is that correct?
Correct.
And then looks like October 6th, they alleged that you failed to take a test, a drug test, is that correct?
Correct.
Likewise, on the 14th, same thing. There was a test requirement that you did not take. Correct?
Yes. Correct.
And it was, in addition to that, you were to provide proof that you were attending the Family Against Narcotics meeting in September or October. You did not provide that proof, correct?
Correct.
Finally, you were required to provide proof of attending intensive outpatient substance abuse counseling, and you did not provide that proof. Is that also correct?
Correct.
Yeah, I'm satisfied.
All right, the court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violations, indicate technical violations 4 through 8 will enter. And counsel, as to sentencing.
I don't know if Mr. Belcher wants to say something as defense. Mr. Belcher, obviously, I don't know. I mean, he's struggling with addiction problems. I would say we have a situation, this public intoxication. He didn't hurt anybody, didn't hurt himself. It's unseemly that he's in a position in his life where his intent was he was sleeping outside at the car wash, but this is the man at the end of his rope. I know this court's done what it can to try to help him. recommendations and the orders from the prior case. I don't know what limited him from complying with that. All of those things were certainly in his best interest to get into programmed to get the education, to get the support. It was an opportunity to get him back in that right direction. If the court can figure out a way to do that, this guy needs help, but obviously he's not doing a lot to help himself. So can't kind of convince the court something that's just not clearly obvious to everybody. But again, is he the world's worst criminal? No, he's hurting himself. Yes, he's hurting society, but he was loitering on the first case. And in this case, the police saw him walking to where he was going to spend the night. He didn't hurt anybody. There's no indication that he blocked traffic or that he was, as I said, grand scheme of things, these are not heinous crimes. And as I said, the worst of it is he's hurting himself. And I think he knows that. And if he had a solution to it, I'm sure he would have applied it already. So leniency, the court can show that.
Well,
Appreciate it.
we did try to help your client.
I understand.
He was referred to the 23rd District Court Sobriety Court on the matter on the 25571 B matter. Didn't appear, so he was denied for consideration. Then this court gave your client another opportunity and placed your client on probation, at which point he violated. And so that violation was, let's see here. That violation was because his test in August indicated use of marijuana, high levels, failed the test August 13th and failed the test as ordered August 28th. As a result of that probation violation, the court revoked the under advisement status for the possession charge, ordered 15 days jail, suspended. So I allowed your client an opportunity to continue to assist himself. And he did not avail himself of that opportunity. Instead, he just ghosted us and didn't even appear. And further, while he was on bond, he had used cocaine, marijuana, alcohol, and whippets. And the court, as a result of that, sentenced your client to 5 days jail. That was back in June, I believe, June or July. And your client has had plenty of opportunities. And so now your client was a .221, significantly intoxicated, so much that he was stumbling and potentially could have fallen into the path of travel of the vehicles, since he was on 4th Street
And talking before.
in Goddard.
I'm not talking go outside.
And so, sir, do you have any sort of housing, or are you you're homeless, correct, sir?
Correct.
And where's the last place that you were residing?
The last place was, I don't know, my friend was letting me stay at his house for a little bit, but right now it's the Fast Splash outside.
Okay, and so why are you not living with your friend anymore, sir?
It was just a temporary thing. And
Okay. So, sir, you've been afforded opportunities that you have not availed. Here's a question I'm going to ask you. Are you interested in availing yourself of opportunities for treatment?
yes.
Good. So what this court's going to do, counsel, is the court's going to adopt the recommendation of probation. The court's going to revoke probation. 75 days jail to be tethered to treatment through the Wayne County Jail. Plus the 15 days from the jail review that were held in abeyance. So the total is 90 days jail. I'm also on the 26552 matter going to order 60 days jail concurrent with the 90 days jail on 25571 B. I will waive your fines and costs again, as I've done on the other one. Good luck to you, sir.
Thank you.
All right. Good morning, Mr. Benson. Again.
Good morning.
All right. We're on the record of the matter of the city of Wyandotte versus Gregory Benson, 26553.
Good afternoon, Your Honor. Neil McGloy here on behalf of Gregory Benson. Mr. Benson, please state your name, sir.
Gregory Benson. Gregory.
Thank you.
Okay. And counsel?
Yes, my client waived formal reading and stands mute to the charge.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and then as to the pretrial. I'm sorry. It does appear as though you took this opportunity to pre-try this matter with the prosecuting attorney, correct?
That's correct.
All right.
Client prepared to offer a plea of guilty to the charge.
All right, sir. I'm going to have you please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
All right. And sir, you heard the plea that was placed on the record, correct?
Yes, Your Honor.
As to the charge, sir, of disorderly conduct, how do you plead?
Guilty.
And you've gone over your advice of rights with your attorney, correct?
Yes, Your Honor.
And you understand all of those rights.
Yes, Your Honor.
You also understand, sir, by entering into a plea that you'll be waiving some of those rights.
Yes, Your Honor.
And
Yes,
you
Your Honor.
also understand, sir, that you understand the possible penalty, whether in this court, any other court, or administrative agency.
Yes, Your Honor.
Hey, can you look to see when he was recently released from Wayne County Jail, please? Right, he was just sentenced March 25th.
I bought came up with 1,000.
Just for a moment. And sir, has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
All right. And please party your client.
Yes, I will. Mr. Benson, you're calling in the city of Wyandotte yesterday.
Yes.
Mr. Benson, yes, thank you. And there was a report, someone contacted the police and they said that there was a person without clothing laying in an alley in the vicinity of 1103 4th Street. Was that you?
Yes, Your Honor.
Not Your Honor. But
don't demote him.
Yes, sir.
Don't insult me. I'm sorry. Mr. Benson, and at that time, you had contact with Wyandotte police officer, is that correct?
Yes, Your Honor.
It's okay. We'll move forward. And then at that time, you had alcohol in your possession and you had a blood alcohol level of 0.101. Is that correct?
I've been trying to go down to team. Yes, sir.
We'll get to that. Hold on. Please try to answer my questions. So you had an interaction with the officer and it determined you had been drinking, you had alcohol, open alcohol with you at that time. Is that correct?
Yes, Your Honor.
Okay. And do you agree that constitutes disorderly conduct?
Yes, Your Honor.
Thank you, Your Honor.
Okay, so the court will accept your plea as knowing, voluntary, and factually accurate. I mean, I would think that him laying unclothed and his behavior for that would qualify as disorderly, but counsel as to sentencing.
Situation, Mr. Benson, you know, some of his history, he's advised me and he just tried to interrupt me and explain to the court that he has an appointment with teen mental health. Apparently that other matter, like you had just referenced, May 1st, is that correct? Mr. Benson, you have some you have an appointment with teen mental health?
Yes, Your Honor.
And he is diagnosed. Apparently, he was off the medications. He has some sort of a mental disorder. I don't know that he's I don't believe he's completely disabled by that, but he's been diagnosed with some psychoaffective disorder, schizophrenia perhaps. And he believes that his conduct that day, he was off his medications, and that might have contributed to some very, very, very poor treatment of that, right? And so, yeah, I don't know how don't know how I would handle this if I was promoted to judge. This is a difficult case.
Well, here's what I'll say that I'm, Ellie, Autumn. Yeah. Okay. Can you pull up his most recent one from February, please, and tell me what I ordered? Because I'm pretty certain I ordered 90 days jail. I don't know if I ordered temporary treatment.
30 days.
Just one moment, sir. Yes, from February. Looks as though it was February 21st. What does it show my sentence was that I ordered? 90 days jail? 51. Credit 51. So by my calculations, that's still 39 days. And when did I sentence him? Was on 3. Well, when were you released, sir?
30 days ago. I was trying to walk down to team mental health. I've been going down to team. I walked out of my cone. I was supposed to went to team mental health.
Sir,
on the 30th.
Sir, just one moment. Just one moment. Because I'm pretty certain I also told you to stop coming back to Wyandotte. You don't live in Wyandotte.
I just my family are dead and gone.
Sir?
I've been trying to do better.
Just one moment. Mr. Benson, please stop for a moment.
Okay.
I ordered you 90 days jail on March 27th. Credit for 51. That means you should have still been serving. Stop talking. Mr. Benson, stop talking, please, and stop interrupting my record.
Yes, sir.
Okay? So you should have served 39 more days. So by my credit, you should maybe just now, or by my calculations, you should just now be getting out if they're giving you credit for certain days. Otherwise, you should have still been in custody. I can assure you that you should have served more than 30 days.
I got time served. I did 3 months.
Sir, further, you have a number of warrants out from other jurisdictions. So I'm really not sure how you were released. Additionally, I am fairly certain I ordered you not to return to the city of Wyandotte upon your release from your last order of jail. You were just, sir, team mental health is right there isn't it right there off of Jefferson, downtown Detroit?
No, it's off the 14799 Dix Toledo Road. I went to see
Hey, not Wyandotte. Still not Wyandotte, sir. Still not Wyandotte.
That's on Southgate. That's where my caseworker at, and my case management over there. I got
Okay,
see.
that's great, sir. That's not Wyandotte. Yet you were found in Wyandotte again. Unclothed. You didn't have any clothes on, sir.
Okay, yes, ma'am. I'm trying to do better.
Some very lewd behavior.
Most of my family are dead and gone. I lost my brother. I lost my mother, my father, 40 years back. My grandfather dead and gone. My auntie
Mr.
dead and
Benson.
gone.
Mr. Benson.
Yes,
I
ma'am.
can appreciate, Mr. Benson, I can appreciate that that's tough and that that's a struggle for you. However, I have said, stop coming to Wyandotte. If you want to visit the court, you can do so a different way. You don't have to keep getting arrested, right? But since you're not allowed in Wyandotte, you can't come visit the court.
Yes, ma'am.
However, that's not why you were arrested. You were arrested because you were laying in the alley, naked, and doing some other acts. In addition, you had consumed alcohol, which doesn't bode well for you ever. Here is what this court's going to do. I'm going to make sure, sir, that you are not coming back to Wyandotte or any other city for a little while, and that you're going to be getting your treatment that you're requesting. So this court's going to order, find that there's not reasonable grounds to depart from MCL 769.5. The court's going to order 90 days jail. You are to be tethered to treatment through the Wayne County Jail. Waive fines and costs. That's the best I can do for you, sir.
Can I go home today?
Sir.
I just got released, Your Honor. My family, I'm not gonna make it in jail.
No, sir. You're going. Excuse me. You are going back to jail, and they are going to tether you to treatment. That's what's going to happen. That's what's happening. Do you understand that?
Yes, Your Honor.
Okay, very good. Have a good day.
Come on.
Okay.
Betsy, come on. We're gonna go back.
Mr. Best.
Come on.
Mr. Williams, I mean, deeply you gotta be.
Okay. All right, let's go. Let's go. Oh, yes, I'm so sorry, Mr. Globus. I had to do the Riverview in custody first because it's in custody. I know I said I was going to do that one next, but I have to do this one. Let's go on the. Oh, Mr. Solers is back in custody. Okay, let's go on the record in the matter of the state of Michigan versus Brandon Solers, 26556.
Yeah, Your Honor. Your Honor, John Goldpaw, P 30758 on behalf of Mr. Scolds. Scolds, please put your name on the record.
Good afternoon. My name is Brandon Solers.
Okay, good afternoon. And so, counsel, as to arraignment for your client.
Scolds is charged with 1 count of domestic violence. I have discussed this matter with him. Mr. Scolds would plead, I'm sorry, he would stand mute to the charges, waive a form reading of that charge, ask the plea of not guilty be entered.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. And the court will schedule this matter for pretrial. Counsel, the next date, well, the 14 days would be, would be 1 day outside the 14 days for May 14th. Do you want to go over time with your client?
I have no objections to that, Your Honor.
Okay. Can you just go over that with your client on the record, though, please?
Mr. Towers, you have an absolute right to have your pretrial scheduled within 14 days of the arraignment. The next state date, which this is a state case, is not available until 15 days from today's date. Are you willing to waive that 1 day with respect to that?
I am, and I'm also asking for a
We're
personal
gonna get to
bond.
that. I understand what you're asking for, sir.
Okay, so the court then will waive the time. The court will also schedule this matter for pretrial on May 14th. I'm sorry? 10:15. Okay. All right, counsel, as to bond.
As the bond, Your Honor, Mr. Sollers is 35 years old. He is on probation to this court. He's not on parole. He's on probation to this court. And I believe that's for a person or
Right, it was a restricting it was an R&O. That was amended. Let me see here. There was an R&O that was amended, a felony obstructing police that was amended to disorderly conduct. Was just sentenced December of 25.
That is correct, Your Honor. It's also my understanding that he did have a no ops conviction in this particular court. He did 10 days on that as well. He is not employed at this point in time. He's informed me that he is looking into becoming for disability because he has epilepsy. We're asking for a bond. He's asking for a personal bond. I indicated that based on his probation status, etc., that I did not think that was likely, Your Honor, and we now have a court date so we can address these issues.
Well, sir, who's your probation officer?
It's Miss Shaw.
Miss Shaw or Miss Shine?
Mrs. Shaw. Mrs. Shaw.
Okay. All right.
I did indicate, Your Honor, that I anticipated that a probation violation.
Hey, can I say something, Your Honor?
I would suggest you don't at this point in time, but that's up to you.
If you want to speak, sir, you sure can.
Well, I just wanted to say that I have appreciated what the court has done for me so far. Mrs. Shaw has been a very respectable probation officer, and the argument that I had got into with my mom last night.
Sir, you may not, sir, I don't want you speaking about the case.
All right.
Not talk about the case.
All right. And so, sir, where do you live?
I live in Riverview Towers with my mother.
Really? She claims that you're not supposed to even be there.
She has let me stay there against the manager's word. She has went against the manager's word to let me stay there until I have got some money together just so I can have enough money to get a car.
Well, sir, where do you work?
I don't have a job at this moment.
Why not?
It's been hard for me to leave out of that building without being seen by the management. And my mom has asked me not to do that. So I have not been in a position to be able to leave out, with my mom asking me not to leave out of her building Cause this lady that she lives with, Mary, is trying to give her all these problems. And
Sir, let me just say this. First of all, by staying with your mom at the Riverview Towers, you're putting her residence in jeopardy because you're not over 55 or whatever the age limit is, the minimum age that you have to be to live there. Second, you're telling this court, I'm not sure if you've heard what you're saying, but you're telling this court that you've chosen not to work so that you could stay with your mom improperly.
that's not exactly what I'm saying.
Please hold on. Thereby not being able to work, now you can't get a car, so you can move out.
That's
That
not
doesn't even
exactly what I'm saying. It might be what you have heard, but the jobs that I have access to are, for one, because I have epilepsy, the ones that I have access to. I have epilepsy, and I'm just now starting to feel like I need to go to Social Security office and claim for disability.
Okay, well, that is something different than what you said the first time. But in any event, I'm going to help you with all that because you're not allowed to return to the 13333 Pennsylvania Road address. You're not to have any contact with your mom. That's phone contact, text message, email, social media, third party, anything of the like. You are also, sir, not allowed to possess or consume any alcohol or drugs unless prescribed. You're not to possess or have access to firearms or weapons, and you're not to be released without a GPS tether through the Wayne County Jail. And the court's going to also indicate a $10,000 10% bond.
Holy shit.
I'm sorry, sir. You're on the record. That's not appropriate. The court wants to ensure the safety of the public as well as the safety of Miss Moore.
Thank you very much, Sharon.
Thank you. Have a good day.
All right. Thank you, everyone. Please take a seat. This is file number 205282 DC. The matter is captioned Murphy versus Murray. So we have Mr. David Murphy here this morning. Ms. Shelby Murray is here along with her attorney, Mr. Kent Wood. Actually, you guys are kind of flipped on your seats, but it's okay where you're at for now. But Mr. Murphy is the plaintiff.
Yes, I'm sorry.
No worries. There is a pretty significant history in this case, and the court will set it up. The court had entered an order back on September 9th of the year 2024, holding all of Mr. Murphy's parenting time in abeyance. There's a huge history with these parties, with the children, PPOs, domestic violence, harassment. Cease Mr. Murphy's parenting time on September 5th of the year 2024. Mr. Murphy, the following year, in July of 2025, filed a motion asking the court to give him another chance and start parenting time anew. The court thought that, well, you know, it's always good to give somebody a chance. If kids can have their father in their lives safely, then they should. So I referred the matter to mitigate the issue and see whether or not it's in the best interest of the minor children that their dad be back in their lives. The parties came to an agreement on September 30th of the year 2025, and they placed their agreement on the record. Mr. Attorney Wood prepared an order, but Mr. Murphy wouldn't sign it. And it went a really long time with no activity on the file because Mr. Murphy wouldn't sign the order. In fact, Attorney Wood had to, you can shake your head all you want, but I'm going to get this out. You're going to have a chance to respond, but right now I'd like you to just sit there and listen, please. Okay. In fact, Mr. Murphy had to file a motion and ask the court to enter the order because Mr. Murphy wouldn't sign it. The court did get that motion, and it wasn't until April of this year that the court was able to enter that order, which set up a framework of what Mr. Murphy was supposed to do before he could resume parenting time. He was supposed to submit to a counselor. He was supposed to submit to alcohol and drug testing. Actually a drug and alcohol assessment. There were just a lot of steps that the parties agreed Mr. Murphy would have to take before he'd be reunited with his children. But we lost a lot of that time because the order wasn't entered from September until April. In any event, the order was entered on April 17th of the year 2026. And then I think we're good to go. We're back on track. But then Mr. Wood files a motion with this court on April 24th and asking for ex parte relief, and that means relief without a hearing. And the allegations were that Mr. Murphy was attempting to contact one of the children through school, called the school and said, I need to talk to my daughter, have her come down to the office. And one of the school personnel, teacher, principal, or whomever, called Ms. Murray and says, hey, is this supposed to happen? And so Ms. Murray was very concerned about this attempt at contact. And Mr. Wood then asked the court to enter an order preventing Mr. Murphy from contacting the children's school, which the court did. It did sign the order. But
I'm sorry, but I haven't seen my kids in 5 years. I don't even know what.
Whose fault is that?
Not all mine.
That's your fault. It absolutely is your fault.
No, it's not.
Do you want to have a hearing or do you want to argue?
I want to see my kids.
Do you want to have a hearing or do you want to argue?
We can have a hearing. I want to see my kids.
Are you sure we can have a hearing? Because I'd like to get through
I
this.
have no control. You're in control of everything. All you guys are.
Meet me at the podium. Please raise your right hand. You promise that you will tell the truth, the whole truth, nothing but the truth, so help you God.
I have no choice, yes.
Do you, yes or no?
Yes.
All right, let me ask you a couple questions. Let's see who has control. Have you located and set up counseling with a reunification counselor?
I didn't agree to
Did
any
you
of
or
that.
didn't you?
No. I don't have insurance.
Did you or didn't you
Laid off from my
complete
job.
a recommended treatment and services following a prevention and treatment services through PATS? Yes or no?
No, but I've done a bunch of that
you
through
didn't.
my probation.
You may
already.
have a seat. You
Okay.
didn't do either of those things that you said you were going to do to be able to see your children.
Yes, sir.
That's on you.
Yes, sir.
The court signed the order. Mr. Wood, come on up and give me your argument as to why that order ought to continue.
Oh, Your Honor, thank you. The reason we'd like it to continue is that the agreement kind of implies that the contact that will be established between dad and the children would happen through the reunification counselor and making sure dad is taking care of some of the treatments from some of the things that were related to his past use of alcohol and drugs, and then keep the children safe. Being able to go to the school to either speak to the children or potentially remove the children from the school would kind of thwart the purpose of that order. I've attempted to try to talk to Mr. Murphy about this, but he refuses to have any real discussions. He claims he's at a different address and refuses to tell me what his current address is. So we're just concerned that he's going to try to use the ability to access the school, and the school has made it clear to my client, and her understanding is that unless there's a court order that says that dad can't take the kids from these places, they're not in a position to stop them. Or if he can't have the contact with them at these places, they're not in a position without a clear order to say so. So we would like the order to continue just so that it kind of fits with the order that was agreed to between the parties and follow through with that process. And then as that goes through, we can readdress this issue.
Very good, Mr. Wood. Thank you. Mr. Murphy, this is your opportunity to respond to Mr. Wood's argument. I'll need you at the podium if you care to respond.
Can I ask, what I did to my kids to not be able to see them? What have I done to my children? Because a relationship there failed. I was a drunk piece of shit. I'm sorry for cussing for a long time. But I changed. I went and got sober. I haven't seen my kids in 5 years. They cut off all contact, phones, everything. I want to see my kids. What's wrong with me calling? I have a recording of me calling. I didn't do anything wrong. I called and asked for my daughter to have my phone number. They took all contact with my children. It's been 5 years. I want to see my kids, sir, please. That's all I want to do. I want to see them and I'll walk away. I'll never bug this lady again. I want to know they're safe. I haven't seen them in 5 fucking years.
You swear again.
Sorry.
You swear again.
Sorry.
You swear again.
I'm
You're going to
sorry.
be in contempt of court and you're going to go to jail.
Okay.
Okay, this court has given you respect. It asks for the same in return from you.
Being on my mother's floor.
Have you said everything you wanted to say regarding this issue?
Yep.
Have a seat. The court ceased parenting time between Mr. Murphy and his children because it made a finding that continued contact clearly and convincingly convinced the court that that contact would emotionally or psychologically harm the children. It really tried to break towards family reunification when it allowed Mr. Murphy's second integrate with his children. But it seems like that was a mistake because of Mr. Murphy's behavior in the courtroom and his inability to follow orders. So here's the order moving forward and his inability to do anything that he agreed to do back in September, starting with agreeing to enter the order, which would set up the framework for him to see his children. Mr. Murphy complains that he hasn't seen his children, but the reason why he hasn't been able to see them is all of his doing. Number one, drugs and alcohol, domestic violence. Number two, he won't do the work that he needs to do to reunify. And until he does that work to reunify, he will not see the children, not under my watch. You absolutely will not. So you need counseling, you need substance abuse treatment, and until those things are done, you will not see those children. In fact, the order moving forward today is that there's no direct or indirect contact between Mr. Murphy and his children, and there will be absolutely no contact, direct or indirect, until this court orders it. So that amends the order from the referee, Mr. Wood. The counselor does not have the authority to start parenting time. That won't happen until this court approves it. That's the order of the court. I'll take care of that. We are all set and in recess.
Thank you.
Oh, yeah. You know, that's how it goes. If you don't do the work for reunification, ladies and gentlemen, when you're in that situation, you don't deserve reunification. Especially when you're acting like that in court. Don't be that guy. I think Mr. Beat said that earlier. Don't be that guy. Ladies and gentlemen, it's just not worth it. I'm all discombobulated here. My Lord. Can I get some? Oh, look. Hey, are the puppies back here? Hey, look. Say hello, Bella. I think she's saying goodnight. And I'm saying goodnight too. Ladies and gentlemen, I am your lone wolf Oosel. How you doing? It's been a long day. Had a lot of crazy court. And I do have a redirect set up to the old Wolfie bot who has some interesting stuff in store, I hear. So stick around for a couple of hours. He'll be going on till about midnight Central Time, maybe a little bit later. So if you're looking for a little bit more court to watch, a little bit more chat, we'll be over there. We'll be over there. In the meantime, ladies and gentlemen, I want to make sure I have everything set up correctly and press this little button here and say thank you very much, Mayor McGrinch, Naybell, Swab, Barry Adams, Kiernoth, Swab. Oh my God. I can't keep up. I can't read all these names like that. Look at all you people. Look at all you amazing people. I see Hutch is in there. I see Legal. I see Hannah. I see Bat Boy is back. Marty is here. Yay! Marty's here. Barry's here somewhere. Mr. Beats is here. Mortimer. Rahul. All our friends from Colin. All our friends from KFAR. Thank you very much, Colin. Thank you very much, KFAR. Thank you very much, everybody in chat. And everybody who has been lurking all night tonight. And now, let's go check in on an Alcium special with Judge Mogan happening over on the Wolfbot channel right now. Huh? Shall we? Yeah, I think so. I'm your little Foosel. I'm your host for these little get-togethers. I find new cases every single day, and I bring them to you live here every single night, 8 p.m., 9 p.m. Central. That's what I do, and you'll be getting a lot more. I got some more videos dropping tomorrow morning at noon tomorrow, and I'll be back here again 8 p.m. tomorrow night. with another bunch of cases from tomorrow, from whatever happens tomorrow. I have no clue yet. We'll find out tomorrow. And I'll see you guys then. Thank you very much for hanging out. I'm your lone wolf Oozle, and I am actually out there. I really am. We'll see you later. Bye. Thank you, Naybell. Holy moly. Thank you, Naybell. This channel operates entirely on the generous contribution of viewers like you. Rub-a-dub-dub. Like, you know, let's get over there and watch Mogan. Ferris Bueller Rock. Bye. Oh, wait, I did that wrong. Here we go.